Dave Kopel from the Independence Institute joins us on the program right now. Dave, good evening to you, sir.
Good evening, and it is a good one.
Yes, it is. Seventh Circuit Court of Appeals yesterday came out and said that Illinois' ban on the carrying of firearms in public, whether concealed or openly, you can't do it. There's no process by which you can legally carry a firearm for self-defense outside of the home in Illinois. That's unconstitutional, right?
Yes. And basically, the way the opinion goes, it's obviously unconstitutional. Not even a close case.
Which is interesting because we've seen appellate courts take the opposite point of view. That in essence, the Supreme Court didn't discuss this explicitly in Heller and McDonald, and so therefore we sort of have to assume that the right does not exist, and the court will tell us otherwise. Is that what the other courts are saying?
Yes, and it's a pretty bogus argument because that's the Supreme Court did mention gun carrying in a number of places, including the fact that back in Heller they say one of the exceptions is to the Second Amendment, just like for who can own a gun, there are exceptions for convicted felons and the mentally ill. For where you can carry a gun, the exception is sensitive places like schools and government buildings, said the court. And that is the exception that proves the rule. So they certainly did discuss it. And Judge Posner, who is the furthest thing from a libertarian, but who does, he is super, super smart, and he can read what the court said. And unlike some of the other judges, he was not inclined to impose his personal opinions, which I think if he were on the Supreme Court, he would not want to interpret the Constitution this way. But he had the commendable intellectual honesty to follow what the Supreme Court said.
Yeah, this is a judge, by the way, who, as you say, like he didn't necessarily agree with the Heller decision, did he?
No, he wrote an op-ed in the New York Times, an article in the New Republic magazine saying why he thought it was wrongly decided. Basically saying you can have, there's good arguments on both sides about history and the original meaning, but he prefers that the Constitution be interpreted narrowly, what he calls a thin Constitution.
Uh-huh.
So, yeah, this ain't, some guy who hangs out in duck blinds with Justice Scalia. He is a personally anti-gun guy, but also smart, logical, and certainly in this case, commendably intellectually honest and committed to doing the role of a judge, which on constitutional issues is when the Supreme Court has clearly told you how to decide cases, you decide them that way.
Yeah, and you're right. I mean, look, this is what we want from judges. We talk about activist judges and legislating from the bench and things of that nature. But when you have a guy whose personal opinion is perhaps that the Supreme Court got it wrong in Heller, but based on the Supreme Court's decision, based on the precedent in Heller and McDonald, you can reach no other conclusion other than we do have a right to keep and to bear arms, and that right, in order to exercise our right of self-defense, and that right of self-defense exists outside of our home. It has to.
Yes, because otherwise, as he explained, having the phrase "bear arms" would be kind of pointless in the Constitution. You can keep your arms at home, but if obviously the import of bearing is outside the home.
Yeah, and I think the statement that the judge made in the opinion was that you're more likely to be attacked on the street in Chicago than you are in your apartment 35 stories up.
Well, yeah. In fact, according to the U.S. Department of Justice, 82% of violent crimes happen away from the home.
So, given the fact that he explicitly referenced Chicago, Dave, I know you've probably seen the editorials and the statements that have been coming out urging Illinois to adopt like New York City style concealed carry laws. That to me would seem to invite certainly another lawsuit, probably a smackdown. If you've been told explicitly you're violating the rights of these people, and then you go out of your way to try to violate the rights of as many people as you can.
Well, then you say, yeah, we're going to give a license that we'll have a licensing process that is theoretically available, but in process the only people who get it are retired cops doing security and diamond merchants. And celebrities.
Right.
I think that's not going to work. But more importantly, because of all the work of NRA volunteers in Illinois, we have a legislature that already has a majority that wants a shall issue law.
Absolutely.
And
Oh,
so
absolutely.
I don't think they're going to turn around and say, oh well, we're going to go do we'll do a law that's New York City's of may issue in theory and virtually never issue in practice.
Yeah, I don't know. I don't think they can get that either. I mean, last legislative session, I think we were 6 votes away from a veto-proof supermajority for shall issue right to carry in the House.
Right, which is 60% in Illinois.
Exactly. So you're already over the 50% mark for shall issue right to carry. You're not going to be able to convince those legislators now, after a court has said absolutely Illinois residents have a fundamental right of self-defense outside of their home, to change their mind and support weaker legislation.
Right, and do some kind of sham. And this is a key point, which is it's great to have, good law, and it's essential for NRA members to be members so that the NRA has the funds to support good lawsuits like this, which result in crucial wins. But that's one arm of the combined arms strategy. You then need the legislature that can back that up and bring it to victory. If the NRA were, say, only an organization that did lawsuits, then we might well have a anti-gun Illinois legislature that would do this kind of sham thing. So, the election volunteering absolutely goes hand in hand with the legal work.
Yeah, no, absolutely right. And this is, as you say, a perfect example of this. Now, in the opinion, Dave, is there anything that the judge discussed that I haven't brought up that you thought was particularly interesting or important for gun owners?
Well, certainly from my point of view, by far the most important thing was that I was cited by both the majority and the dissent.
By both the majority and the dissent?
That's right.
Wow,
my
Dave.
article, the Second Amendment in the 19th Century, was cited by the majority, and my article, the Second Amendment in the Living Constitution, was cited by the dissent.
Okay, so I'm kind of curious. I always kind of view you as a pro-gun guy. I'm curious, what did the dissent actually cite?
For the accurate point that in the state court cases especially of the 19th century, that concealed carry was often considered outside the scope of the right to keep and bear arms under state constitutions, and that's true. But of course, what that goes with is that most of those states had no restriction at all, not even a licensing system on open carry. So, I think you could, based on those 19th century precedents, you could make a pretty respectable argument that a state could outlaw concealed carry altogether, and as long as it had some fair system for people to be able to carry openly. But of course, that's not what people want to do today.
Right.
The general social preference is, partly because there's so many hoplophobes out there who might get frightened and wet their pants, is that concealed carry is the preferable means of carry. And even besides the accommodating the unreasonable fears of the hoplophobes, you can make a legislature can make a social decision that will actually have greater deterrence if carry is concealed, because then all the people who aren't carrying can enjoy free rider deterrent benefits from the people who are, since the criminals won't know who's carrying or who's not.
Right. Talking with Dave Coble from the Independence Institute, and so so that's what the dissent cited. What did the majority cite?
Actually, for that same point from a different article, but it also said, but even then, it didn't say what I just said in so many words. But even its point was, a lot of states did severely restrict or ban concealed carry, but Illinois goes far beyond that, because in Illinois you can't carry openly either.
Okay.
There is just no legal way to carry. I mean, this is not a case about people who could carry a gun openly,
right,
and under some kind of licensing system even, and say, no, I want to make it secret. No court is going to today find a Second Amendment right on that. But it's the fact that you can't carry it all in any manner that's the problem.
Yeah, and so to that end, since this is a pure case, we're not talking about may issue or a theoretical right that exists.
Yeah.
There is some speculation that perhaps the state of Illinois, the Attorney General Lisa Madigan, will not want to rush this up to the Supreme Court. Would perhaps ask for an en banc review by the Seventh Circuit. Todd Vandermeide, when we talked to him yesterday, even floated the theory that perhaps they just wouldn't appeal this at all. They would just sort of kind of let this rest because it's up to them, and there would be some concern about a pure case going to the Supreme Court. What?
I think those are legitimate strategic concerns. And the fortunate thing we had in District of Columbia versus Heller was when Dennis Hennigan and the Brady campaign went to D.C. Mayor Fenty and said, "Dude, you lost in the D.C. circuit. Just take it, and go have some harsh licensing system. But you got to start letting people buy guns, buy handguns, and don't bring it to the Supreme Court because we're afraid that." If you do, you're taking a gamble that we might well lose, and the result is that now D.C.'s problem of having to let people own guns becomes nationalized. So I would imagine the anti-gun groups might well be saying the same thing to Attorney General Madigan. Now, fortunately for civil liberties, Mayor Fenty in D.C., after hearing that, said, "Well, yeah, that's definitely possibly true, but." My job is I'm mayor of D.C., and I'm going to defend the D.C. handgun ban as much as I can, and my job isn't really to worry that if I lose, it's going to mess up handgun bans in Chicago.
Right.
So I've urged Attorney General Madigan to defend the Illinois law all the way to the Supreme Court.
Yeah, I mean, me too. Listen, Dave, we are unfortunately almost out of time, but thank you so much for coming on the program. And I guess one last question. This is by far not the only right to carry case out there. Do you think that the court, and I realize we can't predict what the court's going to do, but do you think the court is likely to take up a right to carry case sooner rather than later?
I am cautiously hopeful, and I think those 5 judges who are the pro-rights majority on Second Amendment issues also realize that some of them aren't getting any younger. Actually, John Roberts probably gets healthier and younger by the day because he's sort of been perfect in every way his entire life. Probably never once got in a minute late from recess in school. But 3 of them are getting on in the years, and I would imagine they might want to do what I think is the final major, super high-level thing on the Second Amendment while they're still on the court before they get replaced by an Obama appointment. And, whether or not Obama intentionally says, this is my litmus test, is to pick somebody anti-gun, even if he didn't do that, the pool of people he wants to pick from are pretty anti-gun.
Yeah, absolutely right. Well, listen, Dave, again, thank you for coming on the program, sir. Congratulations on being cited in both the majority and the dissent yesterday.
Well, thank you.